Hello and welcome to Immigration and Jobs Talk Show with me, Dan Nandan. I'm the president of Hire IT People Inc. I would like to wish everyone a happy Thanksgiving. Uh, Without further ado, let's get started with the 60-day grace period. Um, let's just get there. With the you're an H1B visa holder, and there have been massive layoffs in the tech industry. So we wanted to bring together a show discussing with attorney Prashanti Reddy, who has 20 plus years of experience with the immigration law. She can be, if you are in trouble, you are being laid off. We'll try to cover as many questions as possible today. If you have a question, please comment on wherever you're watching by following us at Immigration Talk Show. We are streaming this live on YouTube, Facebook, LinkedIn, and multiple Facebook groups. So without further ado, let's get started. Let's welcome the attorney to the show. Uh, Hello, Attorney Prashanti. How you doing? Happy Thanksgiving.
Hello. Hello. Thank you. Same to you.
So, as we know, we've been reading about a massive layoffs, starting with the Amazon, Google, Cruise, LinkedIn, 1,400 jobs, Epic Games, 830 jobs, and Grubhub, Shopify, Polestar, Roku, Meta, uh, SoundCloud, and Dropbox, and the list goes on. So, as an attorney, have you been getting a lot of inquiries from people who are being laid off?
Yes, absolutely. We have been receiving a lot of phone calls recently. In June, there was a spot of layoffs in the summer, so we received quite a few phone calls then. Um, and
Mhm.
recently, in this last few weeks, also we've been receiving quite a few phone calls on. Everyone seems to be having the same problem: 60 days grace, uh, getting over, what should we do, um, how do we deal with this layoff situation. So yeah, we are getting a lot of phone calls.
Okay. Now, let's get started with the 60-day grace period itself. What is this 60-day grace period, and what is the rule? And I have a lot of questions. I already see people commenting with questions, but I do have a lot of questions. But in a nutshell, can you explain what is the 60-day grace period for the H1B visa holders, and how can they take advantage of this if they are in a layoff situation?
Yes, absolutely. So the 60 days grace period is something that USCIS has come up with to help people who are on a H1B visa. In the past, it was so strict that even one day of out of status, so one day, even if you're out of job for one day, you're out of status. And that was impossible to then follow the law, because you can't leave the same day that that you lose your job, right? There are things that you have to do. There's maybe bank accounts that you need to close, sell your car, take care of your business, right? So it was impossible to leave the same day, and people were incurring out of status time because of that. And so this is a more common sense thing to do, to give some grace period for people to either change status or leave the country and settle their affairs. 60 days. I still think the 60 days is not enough, but it's something. Something is better than nothing. Or in the best case scenario, find another job. And unfortunately, in today's market, it is difficult to find another job in 60 days. But at least, as I said, something is better than nothing. There is at least time to breathe and to figure out, where one stands with that 60 days grace period. So, as I was saying, the law was, so strict that somebody came up with a plan to create a new law. And this new law allows you to have 60 days grace period from the last date of your work, whenever that is, from the last day that you've been on the payroll with the company. You have 60 days to either change your job, meaning file a transfer, or change your status, meaning file a change of status to a B2, F1, H4, whatever it might be, or leave the country. So that's what the 60-day grace period is about.
Okay. Now, when we say 50, 60 days, don't we think, they should find something within the 45 or 50 days, because an LCA has to be filed and prepare the application. And typically, if someone came to your law firm, now they're just left with 10 more days within the 60 days. So is there a possibility to get the LCA, prepare the application in 10 days and ship it out to reach before the expiry of the 60 days?
And that's the problem that we've been having. We've received several people have contacted us, companies and individuals alike, where their grace period is, getting over in 10 days, in 12 days, and they are waiting until the last moment before making their plans. I understand that sometimes you might get a job in the last minute, but there are instances in where people are having to choose between job A and job B, and they're waiting until the last minute to choose, because job A is better. They're hoping that they will get that job A, and they're waiting until the last moment before they compromise with job B, and they're calling me 10 days before, or 5 days before, and saying that, oh, okay, can you please file this for us now? We have this job, we've decided to go with it. So it doesn't work like that. If you have the ability to do so, please file that transfer as soon as you can, and don't wait until the last minute to make a decision. You need at least 5 to 7 days to prepare for the LCA to come. Forget about the time that it takes to prepare it and to vet your documents, etc. It takes 5 to 7 days, business days, just to get the approval once the LCA is filed. And now with Thanksgiving break, it's become very difficult, because Wednesday, Thursday and Friday are holidays. So most law firms will not work. So there have been some crunch periods for us because of that, also because people have waited until last minute. So it takes 5 to 7 business days to get an LCA approved, and then it takes time to again prepare the I-129 petition. So even if an I-129 petition can be prepared while the LCA is being processed, we still need at least a week. You still need at least a week of time or more, because this is 7 business days. It's not 7 calendar days. So I would say at least 10 days minimum, 10 to 12 days, calendar days to, send out your case. So don't wait until the last moment.
So, if anyone watching out there, if you need attorney help, Prashanti can be reached at 212-354-1010. That's 212-354-1010. Or you can email her at prashanti@readyesq.com. And if you are laid off and looking for a project placement, you can reach out to our company. The phone number is 833-412-8472. Easy to remember, 833 H1B visa. Or you can email us at support@hireitpeople.com. That is support at HIREIT people, one word.com. Now let's jump into the next and thank you for answering that question. Let's jump into the next question here. Now, job or the project, if somebody is full time, mostly these layoffs are full time, or the project. Now, most of these employees, they do have a severance pay, once they are laid off. Now, I have read somewhere it is the last day at the job, not somebody can get a severance pay for 3 months. And what is the rule, or how USCIS is going to look at it? If someone's had a termination, say for example December 31st, but then they've had pay stubs until March, or pay stubs or severance pay which is covering, let's say, 3 months. Now, what is the date, the job end date, or the last day they have received a pay stub, which should take priority? Or is it that USCIS is flexible on these type of items?
So, of course, it depends.
We have a small problem with the technical problem with your audio. Can you hear me? Welcome back. Are you able to hear me? We have trouble with your audio. Can you say something, please? Welcome back.
Hello?
We're back up. Sorry for the technical issues out here. I think with the layoffs, there are technical problems because thousands of employees are laid off and our audio is not working. It's expected. So when something changes so big, and we're definitely looking at 30 to 40,000 jobs. People that are going to get laid off, and also 2024 is a big disaster, and you need to plan. And before I get into the next question, if you have a question, please post on the comments wherever you're watching this. We will definitely take those questions. So before Prashanti, before I ask my next question, I have a stream of questions posted by a lot of people here. We'll take one question first before I jump in.
Dan, should we finish answering that question which you asked previously about?
Sure. Yeah.
I think you asked me a question about what is the
Yeah.
date that has to be taken into consideration. Is it the last day of employment, or is it the
Yes.
date of when the severance pay is issued? So let me just answer that question first. Um, so, so what you have to look at is really the last date that you're employed with your employer. So it may not necessarily be the last day that you went to work, but the last day that you were on the payroll of the employer. So sometimes, say, the employer will say, okay, today is your last day of work, but we're giving you 2 weeks notice, and you leave today, but we'll pay you for another 2 weeks. If that is the case, then that 2 weeks is considered as part of your employment, and at the end of the 2 weeks would be your last day of employment. But as Dan was asking, severance pay is a different issue. Severance pay is pay that is due to you, say maybe, or a bonus that is due to you. So there's not actually pay that is for the time that the work that you did. So severance pay would be a different issue. But if it is notice period, then definitely you can count that extra paycheck and use that period to count your 60 days grace.
Okay, so you heard that. Now, we as an employer, we get a lot of these inquiries. People assume that, sometimes the severance and bonuses are paid as a part of the payroll. And now what happens, we also use like a payroll system like Paychecks or ADP. If you're running, they make it a part of their payroll process, and you will still see pay dates on your paycheck. But as attorney suggested, it is actually the last day of employment, and maybe that's just a piece of paper. You have already lost your 60-day grace period, so you got to be careful with you definitely need to talk to an expert or an attorney to really understand the nitty-gritties of how this is going to work. I will take one question from I think it's a LinkedIn comment by Merpreet. Does the H1 period refresh to 60 days every time you lose the job, or it doesn't refresh from the last time? We were going to ask this question, but that's a good question, Prashanti. So he or she wants to know if the 60-day grace period, in terms of, I was going to ask that question, if somebody had a 3 months job, they get laid off and they take the 60-day period, now they have a new job, now again it's for 6 months, so how many times they can actually take advantage of the 60-day grace period?
So it is only one time during your H1B period. So your H1B period is usually for 3 years. So if for that period of time you're allowed to do 60 days, use that 60 days grace period one time. So you can't use it each and every time.
Oh, okay, that's interesting. So if somebody only had a 1 year H1B, then what happens? It's not a 3 years. They were, I think during Trump time, if you remember, they were only short-term approval, 6 months, 1 year. Now, if they are getting, for example, six H1Bs in 6 years, or somebody's on a 140 and they're extending based on the, beyond the 6 year limit. Now, what happens in that situation?
Well, they say each term of H1, then we can presume, well, that's no longer the case. So it's a moot point because they're no longer approving cases for less than 3 years. So as of this point, then we will just take it as the 3 years. If your approval is for 3 years, then during that 3 years, you get that 60 days grace period for one time.
Okay. Thanks for answering that. Now, I have another question from someone, Yashwant. It's a little off the topic, but then relevant to H1B. Can I transfer consular H1B to regular H1B if we change the employer? So I don't know if he's in the country and he's trying to transfer. Maybe he's on another status, another visa, and trying to use it to change it to maybe for a change of status, versus going to a consulate to secure an H1B visa stamping and re-enter the country.
I don't see why not. You can do whatever you want. You can file for consular processing instead of filing for a transfer. That simply means that you will not get an I-94. So if you don't have status in the country, or if there's some other reason you're seeking to do that, the H1 will anyway might automatically get approved for consular processing even if you do a change of status. But if you are intentionally filing a change of status, consular processing, you can do that as well. When you do consular processing, you get a H1 approval, but you don't get an I-94 at the bottom, which means that you have to leave the country and then come back on the H1 again. If you have a visa already in your passport, you do not have to go to the consulate and get a fresh visa because you have a fresh H1. You can use the same visa to come into the country by just showing the new I-797 approval that you have, and you can come in. And that's one way of doing it.
Okay, Yashwant, I hope your question is answered. If not, please re-comment by providing a little more details on if you're in the country, or what you meant by you want to not do the consular processing and apply directly to the USCIS. Now, continuing our topic and my questions, what happens if someone has an H1B extension pending, the I-94 has expired, and now he still use the 60-day grace period? He's working for an employer based on
Right.
AC-21 under
Yeah.
portability regulations, an H1B extension, assuming it's filed in a regular processing. Now, at that point, they get laid off while this extension is pending. Now, what are the consequences, or how this can be handled?
So the H1B grace period applies only if you are presently in status and you have an I-94. If you are not in status, as you will not be if you file a H1B, but if you're filing an H1B extension and your I-94 is already expired, but you have filed the extension before the expiry of the I-94, you are in a pending status, but you don't have an actual I-94. Therefore, in that situation, the 60 days grace period will not apply to you because you have to be in status. You have to be presently on a H1 for it to apply to you.
Okay. Someone just sent out a message on WhatsApp. I think they're expecting more layoffs in multiple companies. So, there's a group
Yeah.
which they've been only talking about the layoffs, and where
Right.
people are laid
So
off. So this is
I
very.
guess, yeah, I'm just hoping next year will be better. If things go down, they have to come back up at some point. And I'm hoping this is a temporary phenomenon, and all those people who have been laid off will be able to find some reprieve. And that's why we're having this discussion as to what to do in the interim period when there are no jobs, when there's, things seem to be difficult. So, I guess, Dan, if that the situation is so bad that so many people are being laid off, and obviously then there are no jobs available, because if there are layoffs, then the chances of more people being in the market, then so there's less opportunity for new positions because they're already being filled up. In that situation, I would suggest not to lose heart. If nothing else works, then you just leave the country, leave, and then come back on a fresh H1, go on a vacation, and then when the situation becomes better, come back on a fresh H1. So I don't think just because you've lost your job and you have to leave, that's the end of it. Just think of it as a stopgap whereby you are working from India, or you're honing your skills, and then you can always come back.
Yeah,
Um, yeah,
so when you said working from India, as a point of this discussion as an employer, while dealing with our clients, the many jobs that are now being shipped to India. So we have requests where they want to hire. I don't want to name the employers, the clients, but then we have multiple requests that they are planning to. It's not the same pay rate, if they're paying you $70 an hour, it could be 20, 25, but you still have a job that you can continue to work from India. But if you are in a layoff situation and you need a company to market your resume, we can certainly help. We have direct clients. We'll do our best. It's a holiday season. Until December, I think this is going to be pretty slow. But then you can email your resume. If you look at the top header, I have my email list at dan@hireitpeople.com. Send me your resume, and I will connect you with one of our senior recruiters to and a specialist to see how we can help you quickly find a job and then file your H1B transfer or an extension. I have a follow up question on the same question here. You did say something about this, but I wanted to go into a little more details on the converting to another visa like a B1, B2, or F1. Now, what happens if for example, someone went to a B1, B2, and the uh, uh, question one is their previous I-94, the H1B I-94 is still valid, while the B1, B2 has expired. Sorry, B1, B2 is pending. They tried to convert change status to B1, B2. And number two, what happens if the I-94 has expired in between? So, and how easy or tough it is to actually just get into people have tried during COVID. I'm not sure, as an attorney you should have those kind of statistics on how many were actually approved to a B2 status. So can you throw some light on this?
yeah. So if basically, in order to, one way of doing it, of staying in status, as we discussed, is, other than filing a transfer, because you might not always get a job within that 60 days period, is to file a change of status. And one could file a change of status to an F1, or one could file a change of status to a B2, or one could file a change of status to a H4 if you have a spouse who's on a H1. So those are the three most commonly used options. B2, because not everyone will have a spouse who's on a H1, seems to be the most popular option, but it's not necessarily uh, a good option. It may be the best option that there is for you, but it may not necessarily be a good option, because the problem with filing a change of status from a H1 to a B2 is the processing time. The processing time, it takes um, 8 to 10 months for them to process that B2 application. And in the interim, then you might, obviously, you'll have to find a job in the interim. Because what will happen then is, by the time the B2 approval comes in, the validity of the B2 will already be over. So it'll be an approval, but it won't have any validity, because when you're filing a B2, you can only file for a 6-month validity period, meaning you can only ask for to remain in the country for another 6 months. So if it comes in 10 months, obviously, then you're not going to be able to use that approval. So within that 6 month period, while it is still pending, most probably, because it's not going to get approved before 6 months for sure, you will have to file again a change of status from a B2 to a H1. And when you do that, you will do that based on the receipt notice. You will submit the receipt notice. You will tell USCIS this is a bridging petition, and you will file it accordingly. But what's happening with USCIS is sending out RFEs for bridge petitions, and there are a lot of petitions that they're not approving, though they themselves have said that a bridge petition can be filed. They're sending out RFEs asking for the B2 approval when they themselves are taking 10 months to approve it, and you have no control over the processing of your B2, and there is no premium processing as of now for B2. They're asking for the B2 approval, and they're sending out an RFE and giving you 80 days to respond. And if you don't have that B2, if you don't respond within that period of time, you can always argue with them that this is a bridging petition and we don't need the actual approval. We only have to show that the case was approvable when it was filed. But again, that argument is not always succeeding in the recent cases that we filed. So this is something to keep in mind. It depends on the officer, of course. But if it doesn't succeed, then what will happen is they will approve the H1B. They will not approve the change of status portion of it, which means that the approval will come within I-94. And then you'll have to leave the country. And if you have a visa stamped on your passport, well and good, you can come back using that I-797 with the stamp that you have. Or you'll have to go to the consulate and get a new visa stamp on your passport before you come in. So that's the situation with the B2.
All right. Thanks for answering that question. We have a question on YouTube from Suresh. Hi, I lost my job in the month of June, and October 19th, my employer sent my revocation, H1B revocation letter to the USCIS. Now I'm in grace period. What are the best options I have? June, July, August, September, October. I'm not sure. I think he's assuming because the revocation was done on the October 19th. He's, from that date, he's in the 60-day grace period. Can you please, answer this question in terms of, the job was, he's done in the month of June. Now, how is that, he has still under 60-day grace period?
Yeah. Unless there is something that is lost in translation with reference to what he put up in the message board. If your last day of work, that means if the last day of work that you were paid for, your last date of payment for the work that you did, like I said, including the the 2 weeks or whatever notice period that they give you, if that was in June, then the grace period is over a while ago, unfortunately.
Okay.
So you are out of status, so you most probably should leave the country ASAP, file for a H1, consular processing, and take it from there. The lucky thing is, the problem is, Dan, that if your H1 is actually withdrawn, then you're also incurring unlawful presence. That's a different thing. So if you have unlawful presence for more than 6 months, if you leave the country, by law, you cannot come back for 10 years.
So it's a bar.
Right, the unlawful presence bar that we're talking about. So that comes into play once the H1B is withdrawn. But if you're within the grace period, then that does not come into play because the 60 days grace period is being allowed by USCIS, and you're considered to be within status during that period of time. But if you're outside the 60 days grace and the H1B has been withdrawn, and the issue here is employers are required to withdraw their H1s, right? By law, they're required to withdraw the H1 once you're no longer working with them.
I'm
So
sorry.
most probably they would have withdrawn it. In this particular scenario, it seems that he's way past his 60 days grace period.
Okay. Now, Suresh, if you got the answer, let us know. You can comment back, and if you need more explanation, or your situation is different, it's not the month of June, but it's still October 19th. So you heard that. So because that was my question to Prashanti about if it was June, it's already way past the 60 days. So you can still come back with that question. Now I have another question from a little, this is something relevant to the 60-day grace period, but then it's a crossover question between, I think, you and me. But I would let Prashanti talk about this first, if I can add to it. This is from Hannah Supriya. It's getting very difficult where every company says they can hire only W-2 full time, but not corp to corp. I think she's working for a consulting or staffing employer, and she's trying to get an opportunity, a project. And I still do an H-1B transfer when perm is in process with my employer company. So, she's kind of probably stuck there because the perm is under process, and maybe she cannot get the W. Now, what happens if she has to leave that employer, get a W-2 full-time job and get the H-1B transferred? Now, what happens to the perm process? Is that up to the employer, or they can negotiate with the employer? They can keep it open. They cannot keep it open. How does it work?
So you might have a problem with the perm because most employers will not keep it open. But having said that, if they do, it is possible because the perm, but the green card is for future employment, right? You're filing this green card and you're saying that at some point in the future, you plan to hire this person. If that is the case, then an immediate layoff should not be an issue. But US DOL, or when it comes to USCIS, they're going to look at it and see whether there is a valid job offer or not for permanent employment, because you were already working for the employer and then you left or you got laid off. So whether they're going to look into the validity of the job offer and question that. So you have to have a good reason as to why how can you, what is the justification for having laid you off now, and what is the justification for hiring you later on when you have a green card. So while it's still possible, there are issues with it.
Okay. I hope that helps, Hannah. But if you still have a follow-up question, please keep commenting. Thanks for those wonderful questions on the comments. Now I have an interesting question here, which was not even, I didn't think about this, but, this is from Fazna. Fazna, can H4 EAD continue to work for 60 days if the H1B is on? It's definitely an interesting question. I would definitely want the attorney to really explain on this. If the H1B's principal is under the 60-day grace period, can the H4 EAD continue to work? Because that's dependent on stemming out of the H1B, right? So can you please explain more, and the nitty-gritties, the legalities of this H4 EAD when the H1B is laid off?
I would say it's USCIS hasn't really addressed it. They don't address every single question. They don't. There's no regulation really explaining every single thing. We have to go based on what their practice has been in the past and try and figure out, or if there's any case law on it, etc. So that's how most of our H1B or immigration law works. A lot of it is they don't have time to write the regulation; they just pass a law, and we are left to deal with the intricacies of it and interpret it in the way that we logically can. In this situation, if you're in the 60 days grace period, you are considered to be within status still. So I would say that, again, with the caveat that we don't really know, I would say logically that a H4 should be able to continue with her EAD because the person is still within the 60 days grace. That would be my take on it. Because the reason I'm saying this is because USCIS has said in the past that if someone is not on a H1 for a temporary period of time. For example, if a person leaves the country for 2 months, 3 months, um, that person is not on a H1. But USCIS has said that the dependent continues to be on a H4 and doesn't automatically stop or cease from being on a H4 simply because the spouse is out of the country and is working remotely for a temporary period of time. So, taking that logic into this scenario, I would say that since there is still a 60 days grace within which they're allowing people to get back onto a H1, etc., etc., you might be able to work. But if you want to be cautious, I would say just stop working for that 60 days and then go back to working on your EAD. After that 60 days grace period is over, if the situation is such that they went back onto a H1. So just to be safe, I would say stop working for the 60 days, wait for your spouse to file the H1B, and once the H1B is filed, because they're allowed to work once H1B is filed, then you can continue working on your H4 EAD.
Excellent. Yeah, if there are any inconsistencies, with this period, and you might get into trouble with your future extensions, or at the time of green card, you never know. So, thank you for answering that question. And now, one more. I want to add something to this. Why not, if somebody's laid off, they if they have a valid visa stamping, why not they go to the home country, for example, India, and start looking for opportunities while being in India so that they're not accruing any type of unlawful status in the country, and come back on the get a new H1B from the new employer, and they can always come back, right, with the if they have a visa stamping, or they can also go for another visa stamping. I think you touched this before.
Right. Yes, and as I said, that was one of the possibilities. But people, for some reason, don't want to do that. They're scared of leaving the country because they think that they cannot come back. It's certainly an issue. I mean, there is more of a risk when you have to go for a visa, because obviously then you don't know whether the visa will be approved or not. But if you're not going for a visa, there is much less of a risk just going through CBP, because CBP usually, unless there's something wrong, they see some issue, they don't usually stop people from coming into the country if they have a valid visa and a valid I-797. So that's, rather than stressing out and filing a change of status and figuring out how to do it, what to do, if you have a job already in hand or you think that you can get one, just leave. Don't, filing a change of status, and that's all very messy. Unless you need to remain here for some reason, maybe to do interviews or something like that, I think it's better to leave, and then if you already have a valid visa, then come back on that visa. That's not a bad option at all.
Okay, so it's better than safe than sorry, right? So, I guess rather than trying, for something which is not going to work, 60 days, you have ample time to just go on vacation, as she said before, rather than being in the country. And this is much worse if you become out of status, then going to the consulate. If you have a job, if everything is great, I'm sure you should definitely get another visa stamped. Now I have another question from Priya. Well, thanks for answering that question, by the way. Now this
Sure.
is a little off the topic, but then we would love to answer your questions, because this is an immigration show. Although we have a topic, we would definitely, if the time permits, we will definitely answer as many questions as possible today. Now the next question is from Priya. Hey, I have a question that if I didn't get picked up H1B after my master's, may I know which option to go further is better, to go further to stay in the USA rather than starting a day one CPT?
Which option is better? Stay in the. What are the two options she has given?
So if after, I think she's doing her master's now, and if her H1B is not picked up in the lottery next year, there's a change in the system, so most likely there'll be less number of more number of people who will get picked up, because now it's person based rather than job based, starting next
Right.
year. Is that starting next year it's implemented, or?
Well, not yet implemented, but we're hoping that it will get implemented.
It was a publication, so not, at least it's not a bill, right? So
Right. It can, if they want to, they can expedite it and they can publish the regulation.
okay, so let me go back to the question once again. So if her H1B is not picked, and what are the other options to stay in the USA? And I don't think she wants to go with a day one CPT.
Well, then, if her H1 is not picked, then she should she can stay, but she can, if she want to work also. If she wants to work, then unfortunately she'll have to do a CPT. But if she doesn't want to work, and she could definitely then file a change of status while she's still on F1 status, um, or she can file an extension of her F1 if she has no option to file a change of status. So, an extension of her F1 would mean then taking additional courses, doing another master's, perhaps doing a PhD. So, that would definitely be an option for her if she doesn't get picked and her master's is completed.
Okay, thank you for answering that. Now I have another question here from Suresh once again. If we don't get job offers within the 60-day grace period, then can we transfer to B1, B2? Yes, we spoke about this, but he's asking about which is better, a B1, B2, or F1 student visa.
So, an F1 is good only if you plan to um, be a student and for pursue that route. It's not necessarily good. This is a very good question, by the way. It's not necessarily good as a stopgap because your F1 processing is also taking time. Yeah, though I think there is premium processing that has been introduced for F1. I have to go and look it up again, but from my memory, from what I remember, I think they've introduced premium processing
So that's
for
interesting. On the I-539,
I-39 F1s. So, I mean, it may not be a bad option if it gets processed quickly. Then you get onto an F1, but you remember the disadvantage is you have to go to school, you have to be a full-time student, you have to pay your tuition fee. So those are the disadvantages of it. And if you're not if you're planning to discontinue after one semester, then you're losing your tuition fee, etc., etc. On the B2, on the other hand, every thing that you do has advantages and disadvantages. The B2, on the other hand, the disadvantage is the processing time, and you have a pending receipt based on which you'll have to file. And I told you this may or may not work. So at some point, you might have to leave. And that process is not necessarily problematic if you don't mind leaving because you're still in status. You have a receipt. So USCIS cannot say that you're out of status. Then you're leaving as soon as that, one of the two occurs before 6 months or before your H1 change of status application becomes denied. As long as you leave within that period, that is not a bad choice as well. Depends on your situation really as to what you would prefer to do.
okay. Suresh, I hope your question is answered. Thanks for that. Now we have another question here. I was laid off. Uh, I found a job before the grace period, transferred my H1B under regular processing, got another offer from a different company. That's good. You have multiple offers. A lot of people are fighting here. You must be highly skilled and experienced. Uh, and they're ready to do a premium processing on my H1B. So she got laid off, and within the 60-day grace period, she transferred her H1B, which is pending. And now she has a new offer with a second employer, but by my grace period was completed, so she completed the 60 days in time. She filed H1B with employer A. Now while that is pending, now she's getting another offer from employer B, which can be filed under premium processing. Now what is the possibility of moving with this second company? Can I still do that?
I would suggest not to. You're already in a fix. You're already in a bad situation. You're trying to make it better. Now you're trying to make it worse. I understand that the second job might be better, but you actually cannot do it because you're not within the grace period. So you'll have to actually um, wait for this H1 to be approved if it's not already approved, and then once it's approved and once you get a pay stub, then you can transfer to and just do a regular transfer to a H1B to the second employer. Don't try and do it now. Wait for your H1 to get approved and to get paid.
Right. So she can always get the first H1B, which is under regular processing, upgraded to premium, right?
Yes, yes, absolutely.
Okay. So I think that's a better option rather than, again, as I said, try to be safe than sorry. So this switching of jobs while, so an immigration case is pending, maybe, somewhat risky. So use caution before you plan to do so. I have another, some of these questions are that people are more definitely talking about. I think we should touch some of them once again. But before I do that, I have a question from Neha from LinkedIn. I have started a job on an H1B receipt notice, and my 60-day grace period, is over. What happens if my H1B transfer gets denied? That's interesting.
Yeah. So if it gets denied, unfortunately, you're out of luck because you don't have any status with a denial of a H1, right? So that is an issue if it gets denied. While you can start working while your H1 is pending, even during the 60 days grace portability, it allows you to work. The AC-21 applies to that. Um, but if you're starting to work and then if your H1 gets denied and your previous H1 has been withdrawn, then you are left without any status. So you'll have to leave and then come back, or you can file while your petition is pending. I don't think you can do that either because in normal circumstances you would be able to do that, but now you're in your 60 days grace. If you're in your 60 days grace, you can file a petition still for a change of status to some other petition. But if your 60 days grace period is over and you're only working based on your pending H1B petition, that's the only status that you have. So if that gets denied, then you're out of status.
Okay. So at that time, he or she has to leave the country right away.
Correct.
And is there still a 10-day grace period to leave the country?
The 10-day grace period is only given to you as a courtesy when you file a H1B petition. They will add it to your I-94. So there's no other 10-day grace period. So when you file a H1B petition and you ask, say, for an end date of January 10th, they will automatically give you an I-94 until January 20th with the 10-day grace period added. That's so that after your job is over, you have 10 days to leave.
Wow. Now, so somebody's H1B is denied today, and, the I-94 has expired. That means they have to pack bags and leave same day. How
Well,
practical? How practical?
you have a 10-day grace. You have a 10-day grace. But that 10-day grace is included in the I-94. You just have to pay attention to it.
Okay.
Don't presume that your status is until the entire period, even and then use up the 10-day grace period also.
Okay. Thanks for
So
answering. Now,
you've been given the 10-day grace ahead of time. So make use of it.
okay. Um, I have another question from Pragati Gupta. F1 to H4 EAD processing can be tedious. That's what I think. She said expertise. So she needs the expertise to understand the process between how much time does it take from F1 change of status to H4 and then eventually apply for an H4 EAD, assuming the spouse has an I-140. What is the processing time, if somebody's changing from F1 to H4 visa status plus applying for an H4 EAD? Are there any faster mechanisms like premium processing? But what happens in regular if the spouse is, also filing the H1B premium processing extension or something same time? Now, some kind of, timeline. Um, uh, Guesswork, or based on your experience, what could be, can you summarize certain items to explain this process?
So the problem with the H4 EAD is that it is taking time. The good news is it's not taking as much time as it used to be taking. They are processing them faster, about 6 months, 4 to 6 months. It used to take 10, 12 months before for them to process the H4 and the EAD. The best option is to file the H4, H4 EAD along with your spouse's H1. So if your spouse is applying for an amendment, is applying for a transfer, applying for an extension, always file your H4 along with his H1, even though you don't need to. Meaning, even though your H4 is not expiring, just file it. Because when you have to file it a year later, it will take a year for it to be processed, or much longer. But when you file it with the H1, the processing time is cut down to the processing time of the H1 because they are processing both cases together. And especially if your H1 is premium processing, then it will be processed in 30 days. So that is a definite advantage of clubbing both applications together. But if you're not able to do that, since your spouse cannot file an amendment just because they feel like filing an amendment, right? There has to be some reason for them to file it. But if there isn't, and if the H1 extension is not coming up, you can only file an extension 6 months in advance. You can't file it before that. So if nothing is coming up, then you'll have to unfortunately file it separately. But the good news is it's not taking as long as it used to. About what I'm seeing is about 6 months, 4 to 6 months is the processing time.
Okay. Thanks for answering. Now
And
this.
there is no premium processing done, but we are expecting that premium processing will soon be available for these kind of petitions also.
Okay. So you heard that if option A is that you file your H4 and H4 EAD, along with your spouse's H1B. If it is filed under premium, you might have a better chance to, get the H4 and H4 EAD approvals at the same time. Now, thanks for answering that. Now, this is a little a different topic or question. An excellent comment from Raj. Raj, I think I'd like to invite you to we should do a debate on this. I'd like to. You can send me an email. I'll still follow you on the comment on LinkedIn. But then, when illegal immigrants who cross the border are given better treatment, why H1Bs treated like criminals? Okay,
Right.
that's
No, no,
interesting.
I
That's
agree.
true.
I
They have
agree. So my position is I completely agree. Uh, I'm not saying that people who are coming illegally. I mean, obviously they are coming in because there is some need. They're coming in. They're being granted asylum, so there's humanitarian need. So while that is absolutely necessary, we can't say that that is wrong. At the same time, when they are legal immigrants who are coming into the country, trying to follow the rules, which are so difficult to follow because they're impossible to follow. Trying to follow the rules, trying to stay in status, right? They have to wait for their entire lifetime to get a green card. It is, and people who are otherwise coming, I mean, I sympathize with them because they're coming due to humanitarian reasons, they have issues, they are threatened, their life is threatened, their well-being is threatened, and they're coming on asylum. But you have to have a parity in and fairness in both cases. If you're offering it in one case, which you absolutely should, you should offer it and have a better system in place for legal immigrants as well. And that's been, I mean, nobody disputes that, I think. It's just that the Congress is in a state of, is frozen right now, and they can't get anything done because there is so much of uh, politics going on and polarization that they can't get any work done. They're not doing what they're supposed to be doing. Our legislatures, unfortunately.
Yeah, Raj, definitely yes. I just wanted to add something to this. When they, myself, when they enacted a law in DC that, even illegals can get a driver license, when I went there with a US passport, I was missing my residential address proof. But then, they can just get a letter from any resident that they're living with them and they can get a license. And I was sent back twice. So, unfortunately, we are living in a different world. And greetings from Bolivia. Roger, I don't think you have a question, but good to see that somebody in Bolivia is watching our show. Thank you. My next question here is again a little off the topic, but it's absolutely fine. Thanks, Raman. I'm currently on my optional practical training OPT. I have an approved H1B in consular mode. Can I transfer my H1B to a different company? Which means he has not worked for that H1B employer. It's in the it's done for the consular processing. Can they still transfer out to another employer?
So you have to file a change of status from an F1 to a H1, and you have to say that you're CAP exempt in your H1B petition. And basically, you have to say that you're CAP exempt based on your previous H1B approval. It's up to interpretation, and this keeps changing over time. But as of now, I think the USCIS is not insisting that it is required to work on the H1 before they consider you to be CAP exempt. So as long as there is a H1B approval, even though you have not worked on that H1, I think it's still considered to be CAP exempt as of the present time.
All right, people who are watching this show, we have 4 more minutes left before we can end this show. If you have any more questions, please throw them in. Comment on wherever you're watching this if you joined late, and always you can always rewind and watch the entire video. But I'll take a next question here. Is the H1B layoff grace period 60-day or extended? We were just talking about it's for now it is 60 days. I think we all should work together, request the Congress to extend this from 60 days. I have done these type of things in the past, but then the looking at the petitions is very, very minimal, because they have tons and tons of petitions. They think that is of more importance, this is of least importance. So I don't know. But then for the attorney, what are the options on the grace period of H1B, which we've been discussing? Again, I think that people have been touching this question, Prashanti. They're talking more about going into B2 F1 visa. I see a lot of questions on these items here, but then we want to summarize this on the changing to B1, B2, or going back to H1 or F1 visa. I at least see about 10 questions, but we would definitely answer that now. But if it's a similar duplicate question, please read through the comments. I know you guys have been posting through different platforms, so you have not seen this. Maybe you're on YouTube, you're on LinkedIn. For some reason, I'm not getting the Facebook messages, but I'll still, get those questions and get them answered later on. So, can we touch this topic once again about getting into B1, B2, or F1? And then coming
Right,
back to each one, not leaving the country. This is a common standard. I have at least 8 or 9 questions revolving around the same topic.
right. So you have three options that I can think of if you have been laid off. You can either file, what you should do is look for another job. I'm just giving you strategizing, and everybody is different and everybody might have a different opinion about it. Just from a strategy point of view, I think you should look for another job for at least the first month. And then in the last 2 weeks, you should then make a decision if you have not found a job as to what you want to do. If you have not found a job by that point, then you should decide whether you want to leave the country and then continue searching for a job and then come in when you have a job. That is the least stressful, because you don't have to worry about remaining in status, because when you leave the country, then your status is not an issue. The second option is to file for a change of status, of course. Now, filing for a change of status, you could file for a change of status to a visitor's visa. You can file for a change of status, depending on your situation, to a H4, which would be the most ideal. Or you can file for a change of status to an F1. I don't think any other statuses would really apply to file a change of status. So if you're filing a change of status to a B2, you have to file an I-539 petition, and you have to submit the forms, the fees, the supporting documents to show that you do not intend to immigrate to the US. Now there's a problem here, because say you have an I-140 approved, um, you have an intent to immigrate. So there's a question in the I-539 form. So it may not always get approved, especially when you say that, yes, I have filed an immigrant petition. Because there is a conflict with an I-539 and an immigrant petition. So that would affect filing of a B2 as well as filing of an F1 in both instances. But anyway, coming back to this, you're only filing to maintain your status and get some breathing room for the time being. You're not really filing to get an approval, because you really can't wait for the approval. That doesn't make sense. So just filing the petition, whether it gets approved or not, might be one option. And definitely the I-1 for having an I-140 approval should make you think about whether you want to do this or you want to just leave the country. So in addition to your I-539 and your passport and your proof of status, like your H1 approval, your pay stubs, you also have to submit an intent to leave the country. So you have to submit a statement saying, I will leave, I don't intend to immigrate to the US, blah, blah, blah. And you also have to show that you have enough income to support yourself. Since you're working, I'm presuming that you have money in the bank. So you can just submit your W-2 tax returns and your bank statements. So that's the process for filing a B2. The process is similar for an F1. The only difference is for an F1, you'll have to submit in the I-20 as well. And the processing time is sooner for an F1. So that there might be an advantage there, but the disadvantage is that you'd have to start school, you'll have to pay the first semester fee, and you'll have to try to balance out when the school is starting and when your F1 will get approved. So whether the DSO will allow you to start classes while the F1 is still pending. So all that you'll have to talk to the admissions office to see how they deal with that situation. So I think there's no harm in doing research in during your first 30 days to see what options you have for an F1. Then of course then you might want to take a CPT after that to continue working. Day one CPT is not an issue as long as the university allows you to do day one CPT, or the curriculum requires you to have practical training side by side with your classroom coursework. So that's the F1 advantages. The processing time will be less. Disadvantages that you have to be on an F1. So it's not that good a stopgap measure. B2 is a better stopgap measure. The disadvantage of the B2 is that it won't get approved quickly. You'll have to file again a change of status from a B2 based on the receipt that you have, and they don't always approve that, so you might have to leave the country at some point and come back. So those are your options. H4, there are no issues for filing change of status. That's great. I mean, it just takes time, but you can file it and at least be in status while your H4 is pending. So those are the few options that we have done, just to reiterate.
Okay. I think next time there are still many questions. Unfortunately, with the time is of the essence here. We've done over an hour now. But before we end this session, I would like to take one last question from Rashekar. This was a relevant question we've had from someone else before. If I have an H1B approved visa for one employer, my question is, can we transfer to another employer before entering the US? And now, to follow up with this, if they're already stamped, can they still use the same visa stamping, or they have to go back to the consulate because they have never worked in the US?
Right. So that's tricky, but I think we can answer it. And again, don't hold me on this, because there are a lot of gray areas and we're giving our best possible answer, right? So, but we always have a caveat for every response that we give. We're doing, we are giving responses to the best of our knowledge with the intention of answering people's questions to the best ability that we have, given all the gray areas that USCIS has. So, and Dan, as you know, every case is sometimes processed differently. So while one case might get approved, the other case might get denied. So keeping all this in mind, there's some questions that are asked for which the answers are a little tricky, but I will go out on the line and still respond to those questions, as you know. So with reference to this particular question, I think Dan, you said the question was that the H1 is approved, but he is out of the country, so they have not worked on the H1.
He wants to
And I'm
transfer.
thinking it's a cap.
That's it.
So I would usually advise clients that if it's a cap case, your H1 is really starting after October 1st. So just to be safe, I would say just make sure you file that H1, whatever you want to file, the second H1, after October 1st, meaning after the start of the validity period of that H1, just to be safe.
So since they
So,
have
and
not,
that's easy enough to do because we're already in November.
so since they have not worked for the employer, there's no question of pay stubs because it's consular
There's no
process.
question of pay stubs. And as we answered a question earlier, I think it's still cap exempt. There's no harm in trying. We've done several cases and gotten approvals, but your case might be the unlucky one, but we have received approvals, and that's the basis on which I'm saying it, that it's worth trying to get a cap exempt approval. With reference to your question about the visa, can they use the same visa? Generally, they can. So they go for a visa, they get a visa approval, then they change their minds and decide that they will go with company B. So they get an approval for company B, but they use the same visa which was approved for company A. They're allowed to do that. But there might be questions at the port of entry as to why you didn't go with that employer. What happened, and then at the time of going for the visa, did you actually have a job with them? Things like that. And if they think that there is some wrongdoing, they might cancel the visa. Um, so just to avoid that situation, you have to be prepared. You have to have a good reason. Maybe your reason is that they laid you off. They did have a job, but they laid you off. So you can show proof of that. So just go prepared to answer that question. But yes, you can go with the second H1 approval and the old visa. You don't have to go for stamping again, and you can travel and re-enter the country.
Yeah, unfortunately, there are a lot of mixed answers. But then, as you rightly said, it is always safe to, maybe just get another visa stamp because, based on my, I remember, I don't know if anything has changed from then, but then 15 years ago or 17 years ago, I sent out an email to Mumbai consulate asking the same question. They replied stating if the person has not worked in the US, it is a good idea. They didn't say this is a regulation, but they said, it's a good idea that they come back to the consulate for a new visa stamping. Now, thanks for patiently answering all these questions on the 60-day grace period. But if you guys have any more questions, you can continue to comment on the same video wherever you're watching. But then if you need consultation or you have a specific problem, I would not suggest to get answers from the internet. You should definitely reach out to a professional. Prashanti Reddy can be reached at area code 212-354-1010. Prashanti at reddyesq.com. I think Prashanti, next week, same time at 2 o'clock, we should do something like Ask Me Anything, so they can, not build on a topic, and because people have a lot of questions about, now there might be more layoffs, and there's a lot of confusion with what happens with their H1B. They're out of country, in the country. So I think we should come up with something next week which focuses on, they ask anything and you just answer them. So we are
That's a
covering
good
more
idea. We
people.
can announce it. We can announce that now. So whoever viewers are there who have not asked their question can come back to us next week on Wednesday, as Dan said, and we will answer your question on a AMA session.
Yes, so same time, same platforms, you can subscribe to our YouTube channel. It's listed up wherever you're watching. It's Immigration Talk Show. Immigration Talk Show is the YouTube handle. YouTube, LinkedIn, Facebook, it's the same handle. And we also stream smaller files on Instagram and TikTok. They don't allow an hour videos here, but then if you have smaller, questions, the questions will be asked during the shows, even if you're not here. But you would see your question answered when you get the notification from these platforms. Thank you, Attorney Prashanti, for helping our community today, and we'll see you next week.
Thank you, Dan. Take care.
Bye.